I'm Teneale.
And I'm Kelsey, and we're financial advisors from 𝐴𝐸𝐺𝐵 Partners True Wealth, bringing you thought-provoking conversations around you, your money and your life on the Wealth Experience podcast.
Welcome back, and for today's easy to digest bite-sized episode, we talk the very interesting and important topic of estate planning. At least we think so, anyway.
Maybe not so much for our listeners, but bear with us.
No, we're going to make it interesting. Now, of course, we are not solicitors, but certainly a part of what we do as financial advisors is to ensure that our clients' full financial house is in order, and certainly plays a part of the process in looking at estate planning. So, what does this episode include? Well, there's a variety of key areas such as drawing up your wills, enduring power of attorneys, setting up trusts, and diligent planning ahead of time to avoid undesired consequences and taxes. Hey, Teneale.
Yeah, exactly. And I think we've spoken about at times having that really good circle of professionals. So having that network working around you, your financial advisor, your accountant, your solicitor, they're going to come with some strategies together on all of these areas. But if we maybe start today back with the basics, the 101 rundown, and then we can get into some of those media planning concepts. So as a bit of a foundation, you should firstly understand that there's certain documents that are required to be able to have a successful estate plan.
That's right. So most people have heard of a will, but just to reconfirm, this is a legal document that needs to be witnessed and not by the beneficiaries of the will itself. So tip number one. If you are going to go see a solicitor, that wouldn't be a problem because they'll give you guidance on this, but just something to be aware of if you're doing a will kit. The will then should give instruction on what your explicit wishes are upon passing. And that includes assets, but also other areas such as guardianship of your children and nuances like that, depending on what's happening in your situation. So I think it's important to mention here that there is a difference between a will by a solicitor, one that's legally drawn up with a professional backing behind it, and one that's a will kit that's very simple. And the fact that it's a will kit, there's so much opportunity for things to be incorrect simply because you're not receiving legal advice or guidance around what actually might be correct for you. So we do strongly encourage you to seek advice from a solicitor as part of this process when you're looking at your estate planning. So another important thing to note for all the individuals out there that don't have a will, and I'm sure there's many of you out there listening that don't right now, and that's okay. Lots of us are guilty of that at some point in life. But if you do pass without one, this is called intestate. And then effectively what happens is the public trustee will administer your estate. And there are distribution guidelines which they abide by, which pass it on to your spouse if you have a spouse. If you don't have a spouse, then it passes on to your parents, brothers, sisters, etc. Now, an important word of warning here. In Queensland, a spouse is defined as having been living together as a couple on a genuine basis, and to receive your estate the relationship only has to be in existence for 2 years. Now, you've really got to think about if you don't have a will, you've been in a relationship for 2 years that can be proved as genuine. That doesn't necessarily mean that you would want to pass on significant assets to them, for instance. So really important to really think about, do I need to get something in place?
And you might not even have started having those conversations so early on in a relationship, or even want to, you know.
Yep.
So you're exactly right, Kelsey. It's about making sure that you've taken the adult step there and are protecting yourself and your wishes and what you'd like to happen at that point in time, which may well be, I'd like all of my assets to transfer to my spouse. But having that document in place is really important. And it's not too big of a job to actually go and do that, to get a will drafted up. They can be relatively simplistic documents. And the one thing I would say is we get questions a lot around, but I don't really have much in the way of assets. But if you think about it, all of us do. We've got bank accounts. If you drive a car, you've got a car. You've got, like you say, your superannuation. It's not an estate asset, but all those other bits and pieces. Maybe you've got some jewellery from parents or grandparents that you want protecting. So all of those things, that's what's important about forming in that will, which I think is a very important area, Kels.
Absolutely. And Teneale, there's another important document there that we need to consider as part of estate planning.
Yeah. So you're exactly right. It's not just the will. So the purpose of the will is I've passed away and now I want my assets dealt with in a certain way. But there's another very strong legal document, which we've spoken a little bit about this document in our podcast, DINKs. Double income, no kids. If you want to have a bit of a listen there, if you don't have any children, but for everybody in general, an enduring power of attorney, an EPOA, that's a very important one as well to have. Now, what is an enduring power of attorney? It's effectively a document that allows someone to legally be you for two different reasons most of the time. One being for making financial decisions. So if I can't look after my needs because I've been in an accident or I've lost capacity or, whatever that case may be, or maybe I've just gone overseas for a period of time, the enduring power of attorney gives somebody the ability to make those financial decisions. So pay money out of bank accounts, pay for bills, transfer assets, all that kind of thing. It also gives can give decisions for medical reasons to somebody else also. So maybe if I had to make some major decisions because my partner was in hospital and they've suffered a major health event, an enduring power of attorney would allow me to make those medical decisions on their behalf.
And this is a real interesting one to know, because I think a lot of people assume that, oh, well, that's my partner, we're married, surely I'll just be able to action something or speak to somebody on his behalf if something is to happen, or her behalf if something is to happen. And that's not always the case. You can't be assumptuous about this just because, you say you're in a relationship doesn't mean in certain areas, medically, the banks, all of those things, it doesn't mean they're going to be able to speak to you and help in times where you really need to be involved.
Absolutely.
And quite quickly too.
Absolutely. And there have been some really terrible situations where one partner has been in hospital and they've been in a car accident and they clearly can't talk. Maybe they're in an induced coma. And doctors these days are becoming more aware of those medical consents, and they're actually calling on enduring powers of attorney a lot of the time. So you can't, like you say, you can't assume that I've been married to this person for 30 years and therefore I have the right to talk to the doctors on their behalf. No, that's not the case a lot of times. So
absolutely. And I think we get to liaise with solicitors quite a lot, and in those conversations, I think they'd said to us recently, if anyone gets anything as a bare minimum, it's your enduring power of attorney, because you can get those drawn up for, depending on how complex it is, a couple $100.
Yeah. And there were some interesting points that have come across in those enduring power of attorneys in more recent years as well too, in terms of in Queensland. So we're talking a lot about in Queensland now.
That's
because
right,
the laws are different state to state. But, in Queensland, enduring powers of attorney 2020, the changes were made, allowed a lot more flexibility in terms of types of clauses that can be put in there. And even things as subtle as some solicitors will suggest, well, maybe we put in passwords, so if something were to happen to me,
in this day and age.
Yeah, technology based. So now maybe you've got to contact a super fund or a bank or whatnot, but I don't have any of the passwords and they're not going to give any of them to me.
That's right.
So really some interesting points there which are important if you ever did have to put in place a power of attorney document. But
So Teneale, that's wills. We've covered off what they are. We've covered off what an enduring power of attorney is. Now there's another, important structure that you can talk to within a will.
Yes.
Which is a whole separate consideration of itself.
Yeah, absolutely. So if we think about, first of all, if I were to pass away and I've got a will in place and I want all this money to go to my husband, how does my husband receive the money from my estate? Well, he gets it in his own name, effectively, through a will, right? So all of the cash transfers to him, or shares or property or whatever those personal assets might be, goes to him in his own right. But perhaps they don't want it in their own right. Maybe we need to talk about things like you're talking about structures, testamentary trusts.
Yeah, so what we're talking about now is a testamentary trust structure that you can outline in your will.
Absolutely. Yeah.
So what are some of the reasons, Teneale, that people might think about using these.
Yeah, yeah. So testamentary trust, it's a death trust. It's a lovely, lovely name for a death trust. What's some of the benefits of it? Asset protection is probably one of the most common reasons. So what does a trust do? It allows me to inherit the assets not in my name. So in that situation, my husband didn't inherit the assets in his name. He inherited them in the testamentary trust, and therefore he can still control that. He can still be the trustee, he'd still be the beneficiary. But if Todd went off and remarried somebody else, and I didn't, that was the point, is that, or he went into a relationship with somebody else, there can be some asset protection for those kinds of situations if there was subsequently a breakdown there, or if I pass it to my kids, and then the kids had a relationship breakdown. So
bankruptcy protection as well.
Yeah, bankruptcy. So if there's creditors coming in and wanting to go after somebody in their own right, if it's in a trust, there's a layer of protection that's involved for it. So it's pretty much a bloodline trust in that regard. You often will nominate your beneficiaries as being your family to inherit the funds and wanting to exclude the outside parties from that money being at risk.
Yeah.
So you asked, what are some of the benefits? We spoke a little about asset protection. Control beyond the grave can be another one. I'm sure you've seen it, Kels, at times. We're not all perfect. We're humans, and sometimes humans might need a little bit of protection from their own selves. So if you did want to make sure that a certain person inherited the money in a certain way, maybe they're not getting access until a later point in time, or maybe you want somebody else to control for that because there are some reasons that they can't. They shouldn't maybe be in control of large sums of money themselves.
So specifically on that one, Teneale, a couple of examples then. You might have children or grandchildren that you do want to pass the estate on to, but they're not of an age where you feel like they'd be able to handle that quantum of money if they just received it as is.
Yes.
So, if they was 18, but you perhaps didn't want them to get it until they was 25 or 30 or whatever that may be, that's when you might build that into the trust, and
definitely
there'll be rules around that, perhaps where it would be more of an income stream, not a capital lump sum payment, and those sorts of things. Or even if there is situations out there, unfortunately, where people do have children or grandchildren that perhaps have certain issues in their life at the time, drug problems, relationship breakdowns, all those sorts of things that you're not saying you don't want them to receive the estate, you just want to make sure that it's going to be distributed to them in the best way for them, based on what's happening in their life.
Personal situation. That's exactly right. Yeah, definitely. And that a testamentary trust, my goodness, is wonderful for that, because you can put those provisions in place, and you do it at the will level. So you do it when you're establishing your will. And then lastly, probably another big benefit, which is not often spoken about, is the taxation benefits of a testamentary trust. So typically, if you have any trust structure in place, you can distribute the income down to different beneficiaries. So maybe I've inherited the money in my own testamentary trust, but I would like to distribute the money down to my son Leo, who is currently 10 years of age. Under a testamentary trust, one of the huge benefits there is that children under age 18 can, or I should say minors under the age of 18, are able to receive the income and taxed as if they were adults. So there's a big differentiator there, because what's the tax rates for minors typically, Kels?
Yeah, highest marginal tax rate, so 47% plus the 2% Medicare levy. So, and if you had a trust that was outside of the will, you try and distribute to a minor, that's the tax rate that they would pay on it. So that's the big difference, I think, in having the trust outside of a testamentary trust versus having it in a testamentary trust from a tax perspective. Yeah,
exactly right. So so that's one big benefit, is that distributing to the kids. Also, you can just distribute to whichever beneficiary is named under that testamentary trust structure. So even if they are over age 18, but you said, well, there's myself and I've got a few kids, and my kids have lower tax rates than I do because I'm working in a higher paying job, just being able to distribute a little bit more flexibly. Or maybe you've got a company or something that you'd like to put that money across into as well that way. So those are some big advantages on the tax side.
So it's thinking about that next generation that you're passing it down to. What's their situation? What's their income levels? What's their family structure? Could they receive it in a better way that could be distributed in a more tax effective manner for them.
Yeah. And again, I do get a lot of people that say, well, why am I thinking about something so complicated in a will at this point in time? To be fair, it's actually not that complex. Your solicitor will be able to set that up quite easily. But if you don't have a testamentary trust in your will, it can't be set up after the point. So you can't have passed away and then they put it in place. It's better to get it set up now and then not have to go back and constantly be adjusting these documents later on down the track. They obviously need to be reviewed regularly, but not changing it for unnecessary sake is a great reason. And also when you start to add up the different places that you might have money coming from. So if I hadn't already just made a decision of what to do with my superannuation money and it paid to my estate, for example, or I had a binding death nomination to my estate, if we think about it this way, even if I'm young and I'm accumulating, I've probably got some insurances in my super fund that have been set up there, that could all form part of the estate. So there's another larger amount of money coming into this pool. So, things like your testamentary trust are not just I've now accumulated a high sum of wealth and now I need to think about it. It's thinking about what are all the sources of where that's coming in.
Yeah, absolutely. And just to confirm, by setting up the testamentary trust in your will now does not mean that it's in place. So it doesn't actually kick in or come into effect until you do pass. And of course, it isn't going to be suitable for everybody and there are some downsides. It's certainly going to be a higher setup cost than what it would to have a very simple will. So just something to think about. And there can be possible succession issues because it can also be really hard to get that perfect too.
Yes.
I don't think there is any perfect way to do your estate planning,
No.
especially the more complex your situation gets. So it's really important to discuss with your own personal circumstances with a solicitor, and that's why we recommend you do go see a solicitor and don't do a will kit. Speak to your advisor, speak to your accountant and all those, the magic circle of people that will really help you give clarity around what will work best for you. So now we understand what the documents are. What then are the strategies that can be often overlooked but critical for a good estate plan? So what are some of those things to look out for? So the first thing I would say is your superannuation. So most people don't actually know that it doesn't form part of your estate automatically. So you either have to specifically nominate who you distribute that to. So you can either say as per my will or directly to this person or these people. And if you do nothing and the nomination expires or you just don't put one in place, because they do expire every 3 years, let's remember, on your super funds for the most part, then again, the super fund becomes a trustee and they will make that call for you. So really important to go, yes, I've got my wills and my enduring power of attorneys or whatever that looks like for you, but don't forget about your superannuation because unless you've set that to your will, there's another factor to consider.
Absolutely. And it just is nice and clean for your executors too at that point in time that they know it's going where you wanted it to go. Another area that's not forming part of the estate as well but is important to consider is life insurance policy. So we just talked a little bit about insurances inside super, just noting that if you hold insurance policies you that are not inside super, you nominate who the beneficiary of that will actually be. So it might be that you've got life insurance in place for $100,000 that you would like to go to a niece or a nephew or a brother or sister or whoever that might be. And it's a great way of leaving money to a loved one that I didn't have to have already accumulated, and that doesn't actually have to pass through my estate, because if I have a direct life insurance policy, I set up the beneficiary, it goes directly to that individual. So that's also a strategy that I see used relatively often for second or third and fourth relationships. So where you might have had a family together, but then maybe you've had a relationship breakdown and then later on have met a new partner, and you'd like to make sure there's some provision for your new partner as well. So oftentimes holding an insurance policy for those kinds of reasons and setting them up as beneficiaries can be a great option.
Absolutely. And there is another factor then, which is tax planning. And we kind of already spoke to tax planning with a testamentary trust, but there's another element to tax planning that isn't relevant to that. And I think we actually spoke about this on a podcast recently around superannuation and the taxable and tax-free components that live within that.
Our clients don't like that one, that area of taxes that we seem to uncover that's little known about.
Absolutely. So bit of a recap. you will have a taxable component in your super fund if you've ever received employer contributions, made salary sacrifice contributions. That's where we see that build up. And for most part, and the income that you earn within the fund to add to that part. So it's quite likely that that's going to be a high taxable component in your super fund. Now, you may think, well, I'm going to access it as a pension, and it's absolutely correct that you can access that tax-free if you're the relevant age to be able to do so. However, when we're thinking about estate planning, if you're to pass that superannuation on, then that taxable component will be taxed at 17% before the beneficiary receives it. So this is why we're thinking about what strategies can we implement here to reduce that taxable component. And you're right, Teneale, not a lot of people actually are aware of that being something that lives within a super fund, because it's not relevant to you, but it is relevant when you pass that on through the estate. So yes, we mentioned the testamentary trust, but also thinking about a trust when you're alive as well. So not superannuation, we're thinking about trusts now. If you know that you have an excess of capital and income that you're not going to spend in your lifetime, there is people in that situation, and a really good strategy could be, which I have actually recently recommended for a client, is to take that extra that you're probably not going to spend. And to know what that extra is, I will highlight, you need to have really comprehensive financial planning around that, because you've got to factor things like inflation, future spending, et cetera, et cetera. But if you do have good clarity on what that looks like, then setting up a trust could be correct for you, because then you've got more flexibility around passing assets on either whilst you're alive or upon passing without you bearing the tax on it. You've got flexibility of who you pass that on to, and you can also have special instructions then around what happens when you pass and who would inherit the proceeds.
We like to have, these strategies that can minimise the tax payable, because we get hit all through our lives on it, don't we?
Unfortunately, yes. Yeah, there's two things you can't avoid in life, and that's death and taxes.
Yeah, we talked about both today. What an uplifting podcast.
It is. I told you it would be exciting, guys. But again, this is a very complex area, and, you will need input from not just an advisor, but also an accountant and solicitor to see if that would be even correct for you. But it's just to go, tax planning, superannuation, all of these things still form part of an effective estate plan, and that can be from a strategy perspective as
Absolutely right. Yeah, and I think it's definitely that we want the best outcomes for people's families. Estate planning is really about making sure everything is in order that way, and making sure you can pass it to the next generation.
That's right. And there are some very real and nasty issues that can come about if you don't have this right. There's examples of children not receiving assets that the person that's passed wished them to receive, or ex-spouses receiving capital that you didn't want them to receive just because you haven't updated your estate planning documents.
And that's an important one, because a marriage breakdown or a separation does not invalidate a will.
It doesn't. Nope, That's exactly right. So that's a really good trigger point if that's something you're going through, to think about updating your estate planning. And also, wealth erosion is a big one, because if you don't have this plan right, that next generation that receives the capital can dwindle it. I think there was a stat from PwC, by the third generation, the wealth erosion has already happened.
Wow. Yeah.
From those that had created it.
Yeah, and wouldn't you hate to see that, when not alive for that transfer, and to see that, but be devastating to actually see that play out. So
absolutely. And remember, these things can happen to anyone. It's just making sure that you're on top of it, knowing what your trigger points are, and making sure that you've got a plan in the first place. So step 1, get a plan. Step 2, continue to review the plan based on what's happening in your life, so you can't forget about it.
Seems like an easy plan.
It does, right? So if you don't have all of these things in place, I would suggest just pick up the phone after this podcast, call your solicitor, call your financial advisor. It is one of those things that generally sit on the bottom of the to-do list, but it is really, really important.
That's exactly right, Kelsey. And well, thank you, everyone. That's it for our episode today. So as always, we value your feedback. Please make sure that you comment if you'd enjoyed this podcast, and if there's anything more that you want to know about the estate planning area, let us know. We will do an episode release with a specialist in this area pretty soon, and we will see you again soon for another Wealth Experience podcast. The opinions of the presenters are objectively ascertainable and are not intended to be financial product or personal advice.